A lot of people were spiking the football thinking that the congressional maps were not going to be challenged. Au contraire. We'll get into that if we have time as well. Lucas Vebber standing by. How are you?
Hey, I'm doing okay.
Okay. Okay as okay. All right. Wisconsin Institute for Law and Liberty has been at the forefront of all of these issues that we have been talking about. Notably, this one on rulemaking, which the headline said was on conversion therapy. I think Channel 12 out of Milwaukee, WISN out of Milwaukee, actually did a pretty good article on it. They were the only ones I saw, explaining that it really wasn't about conversion therapy. It's about rulemaking. So what's the shakeout going to be of this, do you anticipate? And is there a challenge we can bring?
Yeah, so this decision on Tuesday, Tuesday was a dark day in our state's history. I think I can't underscore enough the long-term significant damage that this decision will have on Wisconsinites in every corner of our state. What the court did was they effectively said that nameless, faceless bureaucrats at state agencies, many of whom are still working at home, by the way, get to write rules that have the force of law and can impact your daily lives, and that the legislature is effectively has no power to stop them. And so what we're going to see, and as you noted, the rules that were challenged in here were those two rules that were brought up, but really the opinion didn't even analyze those rules. This rule is all about agency power. It's about power for the bureaucracy, taking power from the people's elected representatives and giving it to unelected agency bureaucrats who are, going to be writing these regulations to enforce these laws. The significance of it, of course, is that it overturns decades of well-settled law and legal precedent in Wisconsin. So, it used to be an agency would write a rule. The rule would then go to the legislature, who would take a look at the rule. If the legislature disagreed with it, the legislature's Joint Committee for Review of Administrative Rules could temporarily object to that rule. They couldn't impose it right away. That power is now completely gone. The only way for the legislature to stop an administrative agency from imposing its own agenda on the people of Wisconsin, and again, unelected agency officials from doing this, would be for the legislature to pass a law and for the governor to sign it. But the governor's never going to sign a law that kneecaps his own agency doing his own bidding at those agencies, right? So that's why I think it was a dark day for our state, and I think it's going to have long-term, significant negative ramifications.
Look, I could just let your mind wander a little bit about. First, understand that the laws that are passed by the legislature then, have rules to implement those laws. That's what the rules are supposed to be about. They're supposed to be about implementing the laws, not supposed to be about coming up with new laws on the fly, but just about implementing the laws. And as I said earlier this week, I said there's also another decision from last week on the DNR that essentially said, feel free if you don't want to go through rulemaking, which requires notice and comment, to go through guidance instead. Just issue guidance documents. And that when you put these two cases together, you might not even know what the new rule with an effect of the law is going to be, because it might be coming under the umbrella of guidance documents instead. And so think about what you could do to conceal carry. Think about which is beloved by many conservatives, many 2A people in Wisconsin. There's so much mischief, or campaign finance, which is already Byzantine. Imagine the kind of mayhem that could be wrought on the business community because of this. It's just, the sky's the limit here. And that's what scares me.
For sure. And, the good news is there are things we can do, right? I mean, there are still agencies are surely going to overreach. The courts are still a recourse here. It's effectively now the only recourse. My team over here at the Wisconsin Institute for Law and Liberty, we've been working overtime for 48 hours on how to address this. Gloves are off, and we're doing everything we can to get ahead of it. The thing that people need to understand now is how rulemaking works, how to get involved in that process, because it's more important now than ever for people to understand how this is and how that's going on. I just strongly encourage everybody to get involved in the fight.
Yeah, again, that's what I'm afraid what's going to happen if we start getting involved in rulemaking. And by the way, we did when Scott Walker was governor. A lot of people showed up to object to the Department of Justice's rules on concealed carry, where they tried to rewrite the actual law with the rules. And thank God for JCRAR, the Joint Committee for the Review of Administrative Rules. That's back when Steve Noss was on it. He's been on it for years. When Leah Vukmir was on that committee, focusing on that committee was one of the smartest things Scott Walker ever did. It was just great for Wisconsin. Well, and if they decide, well, let's just go with guidance instead, I don't even know. It's so undemocratic that you hear all these people, democracy, no kings. You're all cheering Governor Evers being a king. You say democracy, and you've just shut out the people by shutting out the state legislature. It blows my mind, this completely inverted rhetoric that I'm hearing.
Exactly. And as I'm paraphrasing the great Justice Rebecca Bradley in her dissent on Tuesday, but she said the left decries no kings unless it's a king of their own choosing. So, yeah, I guess it's our king, just not yours. Exactly. And this is a decision. And my colleague, my boss, Rick Essenberg, had said previously, this is a decision I think the left will come to regret. I mean, the pendulum will swing back. Imagine if Donald Trump was governor of Wisconsin. Would they have made this decision to give Donald Trump and his agencies all this power? I mean, it's just it's a significant change to the constitutional order in our state, the likes of which I think your average Wisconsinite is not getting because they don't track this stuff as well.
Are there any other states that do it this way?
I'm not aware of how every state acts in this way. I mean, I think the way that the Wisconsin administrative state has developed over the past several decades has been, the legislature is granting power to agencies to write rules, but they did that conditioned on the fact that they would have the ability to have oversight on those rules. So you've completely gotten rid of the oversight, but you've maintained the underlying grant of power, and that's why this is so extreme and so just absolutely radical. And I kind of shudder at what some of these agencies are going to do.
So do I. Believe me, so do I. Tell me about the MAPS case. I know we don't have a ton of time left here, but my friend Jim Troop has said this about 2 weeks ago, and he said, don't everybody get too excited about this. Number one, the Supreme Court didn't reject the challenge to the MAPS. They kicked the can. Number two, there will be more challenges, and here we are with another challenge.
Yep, exactly. I mean, so I tell everyone, what does the saying go? The definition of insanity is doing the same thing over and over again and expecting a different result. But here we are yet again. They've now filed it in circuit court. The previous attempts were all brought before the Supreme Court initially. This filing was made in Dane County Circuit Court. There is a strange procedural process in state law that kind of the first step here that'll take effect. But yeah, they're basically making the same argument. They're no longer saying it's a partisan gerrymander. They're now calling it an anti-competitive gerrymander, which is essentially the same legal argument. They're just sort of repackaging it under different branding now, I think. So they brought that. They're asking for new maps again to be in place before the next congressional election. For the same reasons that we said that the original actions initially had a number of legal and practical problems. So does this case. They're going to need to take evidence. There'll probably be a full-scale trial, a lot of discovery. It's going to take a lot of time.
So I'm thinking, but the idea is to get the maps changed before the next election. And we're talking about the Dane County Circuit Court here. This has now become the rigged court in Wisconsin, because then now you can leapfrog once you get through the Dane County Circuit Court. That's going to give the Supreme Court more of a hook to hang a decision to take that case quickly, I think. And that's my worry too.
Certainly, anything's possible here as this moves forward. And it's something that we absolutely will be involved in and continue fighting that fight.
Well, I do encourage people to support Wisconsin Institute for Law and Liberty, will-law.org.